were enacted on 2nd March 2016,
Yes, yes.
and when the relaxation was still in existence. Okay.
Yes, yes.
Now, Rule 6.3 provided for the appointment of candidates with relaxed qualifications, untrained after the appointment of trained candidates. That you will not see on the paper book, but Rule 6.3 at page 114 of the paper book.
Yes,
That is
yes.
there. If required, I will hand over
No,
a
no, it
note.
is with us.
Therefore, relaxation was extended time to time, and within the extended time, all our clients, all these persons who are there, they have what their
They were participating.
and to who will get this relaxation? Those who are appointed, not each and everyone. Those who are appointed as teachers.
Yes,
After
yes.
appointment, they will get it. They get the and they have done it. Therefore, this they did not have the qualification. It's not that. And in the advertisement, I have pointed out. I do not want wish to again that in the advertisement itself, it was said that upon this qualification has to be obtained within a 2 years after appointment.
Yes.
This is one of
That is not disputed.
that is no dispute. Therefore, we are all trained. Now, my lord, one I have shown it also. Again, I am sorry, my lord, repeating. The Honorable High Court of Calcutta in WPS so and so Chinmoy Doli case permitted the state of West Bengal to appoint untrained candidates. The court's order is there. Untrained candidates as assistant teacher in primary school even after the period of 30.
That is
This is also not this, but they have raised the issue. That's the reason. The point is this, Miller. Point is very limited. But with great respect to our learned friends, they wanted to make it more wide. But we do not have to go that such stage. Point is very limited, but they have traveled hither and thither, hither and thither. Naturally, if I don't give the answer, my lord, your lordships will say that I don't have any answer. I have appointed, I do not have given the reply unless the Mr. Bhattacharya had traveled so much. He is my senior.
That will be answered by Mr. Bhattacharya.
He is not there. Mr. Bhattacharya traveled so much. And in practically, he is so from Vietnam to Platinum, everywhere he has traveled.
That is not at least relatable to this case.
No, not relatable. Just Mr. Bhattacharya is there.
Entire proceeding becomes boring.
Yes, yes. At least with us, compilation. That is, I objected to your lordships. Observe that you will be given the chance. Lord, what is the law of pleading? Even in a writ petition, even law of pleading is very clear.
That you have extensively argued.
Bharat Singh's case, I have argued that.
Yes.
Beyond that, no one can go. After completion, Lord, bar from the bar, one compilation will be handed over, which has become very practice of nowadays. And then in that compilation, so many documents will be given. That is not the practice. That is not the law of pleading. That is not the rule of law. In court, we have to be precise with the pleadings and the evidences annexed thereto.
ঠিক আছে স্যান্ডউইচ একটা দিকে
beseech to your lordships, I will request to your lordships not to look into any other documents in this matter, excepting which are in pleading, or which were only in pleading. Even if the learned single judge has committed a mistake,
Hmm. Yes,
by
yes.
looking into that documents which are not part of the records, and for that reason which have not been allowed to revert even the other sides, these documents cannot be. And my lord, kindly remember one thing, that the first time we are before your lordships, we are not in the trial court. So we didn't get any chance. And at the time of argument, the documents are being handed over. How we will deal with? Not a single document.
Yes.
My lord, Mr. Bhattacharya relied on Standard Chartered Bank's case.
Yes.
That is 2006 SCC 94.
Deemed pleading.
Yes, was rendered in an appeal under Section 10 of the Special Court Trial of Offence related to Transaction and Security Act 1992, Para 1. It was a suit wherein the deficiency of the pleadings can be covered by the evidence, but in the writ proceeding being summary in nature, such recourse cannot be permitted. There is a deficiency in pleadings. My lord, every witness have come. There is a scope to cross-examine, etc. Let's assume a pleading has been made vague.
No, it was a case under the Special Act.
Special Act. That's time.
Suit why you're saying?
No, Special Court.
Special court.
Section 10 of the Special Court Trial of
A
Offence.
suit.
No, evidence was taken. Evidence was taken. That was judgment.
Evidence was taken.
Evidence was taken.
But it was not.
Not a suit. Sorry. Wrong.
Yes.
Now, therefore, there the evidence. Why this evidence is coming court, regular court, that's a different part. Everyone is getting a chance. Then I can ask for this, all right, if with the entry being all persons, I will cross-examine them. My lord, your lords.
Mr. Bhattacharya's argument, if we are not mistaken, his argument was, what are the elements involved in this matter? It encompasses corruption, fraud, etc. So, Mr. Bhattacharya argued that it is a settled proposition of law that suppose A, B, C pleading is required. You have made A and B. You have made pleading as A and B. So, for the specific C pleading, you need not reject it on the ground that there is strictly no pleading to that.
My lord, what is a pleading in a writ proceeding? Can it be vague?
No, on the contrary, your argument is that the original pleading remained. There was no amendment to it.
No.
What was been done? What has been done in this course of action, deemed pleading would not happen.
May I, in short, his case, kindly see what he is asking for, what their clients are asking for.
Yes.
Their clients sought for certain
Similar
considerations. Their clients did not ask for cancellation of any of the employment.
Yes, yes.
Correct. Now, when they have not got it, now they are saying, since I have not got it, soon no one will get it in West Bengal. I have become unsuccessful. Naturally, you will not be no one. And this word is very spicy word, the corruption. Corruption has to be proved. This is in Bengali, which is called chutney.
Yes.
The point, therefore, is before a lordship, whether before the single judge any corruption was proved.
Yes.
Not a one chain. It is a complete, corruption is a complete chain, not the picking up of the one thing.
Yes, Mr. Bhattacharya.
Now, is there any case has been made out that these my clients have given money and got the employment or not? In the gist.
Yes.
That corruption has been proved. That CBI has said.
Yes.
Some persons have got it. Who are the persons? Dealing with the 32,000 cases. 32,000 persons future. Now, my lord, next one is charge sheet of the CBI. My lord, I have argued extensively the charge sheet of cited the judgment to your lordships also. Judgment I have cited. It's an opinion only. That has to be proved. My lord, I cited the judgments. I do not want to repeat. Can an opinion can be relied upon to terminate the service?
Yes.
My lord, in our compilation, I have given it 2022,
What is the name?
volume 12. There is Rajesh Jadhav and another versus state of Uttar Pradesh. Come to Milord paragraph.
So Rajesh Jadhav,
I have cited Milord. I have given a separate compilation of
no,
the
no, no.
judgments.
We have taken note of. You have cited that Institute of Chartered Accountant, then Khetrobasi Biswal, Boluram, then Ranjan Kumar.
These are
This
different
Raj,
parts.
what did you say? Printers Mysore, Chennai Metropolitan,
This is different.
Murli Babu.
Ogulo delay.
No delay. Yes. Now this chart sheet is an opinion you have not given.
No, Milord, I have cited that. Milord, your lordship
Can
will
you
find
give
it.
us the reference, please?
We will give it, get it in my compilation.
2000.
344. My compilation 344. That is at page
No, the name of the
2022, volume 12, SCC, page 200. Rajesh Jadhav and বড্ড কথা বলছিস রে।
SCC page 200.
আমি একটু ডাল হেডেড ভাই
Yes.
প্রবলেম 2022 volume 12 SCC page 200
Paragraph.
paragraph milord 27 তাই তো
7.
paragraph 27
All right. Yes.
milord just I can just want to remind to this proposal milord section 173 CRPC calls upon the investigator to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offense and thereafter conducts an investigation to identify the offense, the truth of which ones. Therefore, it would be lead to the position that the evidence of the investigating officer this evidence of the investigating officer is not indispensable. The evidence is required for corroboration and contradiction of the other materials witness, as is the whole links and presence. Even assuming that the investigating officer has not reposed before the court or he has not cooperated.
Yes.
Now, therefore, it is an opinion stage. Trial has not yet been concluded.
It is tentative.
Trial has not been concluded. Therefore, your lordships, the corruption charges have been made. Let's take it. Your lordship is deciding the case in the civil side when charges have not been proved. On the contrary, today, what we see, all the accused have been enlarged on bail. That doesn't mean he has not committed an offense. I am not saying that. Also, I am saying that doesn't mean the charge sheet is given, that's a sacrosanct.
Yes.
Now, my lord, if the CBI was really serious, take the case, my lord. If the CBI was serious, this case is now pending for 4 or 5 years. They could not have finished the trial.
That is a
Separate thing. But I am saying, my lord,
we understood your
corruption, mere saying of corruption will not do. That's a separate issue. But I am saying so, my lord, because these are the very corruption. To prejudice a court is this word is sufficient. But court will look into that, whether corruption has been established or not. That's my submission.
Yes, Mr. Varma.
And the corruption has vitiated the selection process. Maybe corruption, but here the corruption has vitiated the selection process or not.
Yes.
Right? Now, my lord, next.
How do next?
দরকার নেই তো এটা বলা হয় Namely, the litigations for 6 marks have been taken an argument. 6 marks have been granted. Charge sheet has been shown that the 6 marks have been given extra. Correct? That has been pointed out also. My lord, kindly remember, my lord, I can give the references also. This litigation for granting 6 marks, lead matter Pratibha Mondal, versus State of West Bengal were moved by Mr. Vikas and Bhattacharya, Mr. Samim Ahmed, Mr. Sudipto Dasgupta, Mr. Firdos Samin. They got the order from the High Court, 6 months to be added.
Yes,
And in the charge sheet has said extra 6 months have been given.
very good.
কি দরকার জজসাহেব এখন তার চার্জশিট দেখাতে গেলে তো হবে না it will take time 15
Yes,
but I will give this orders copy I will give it to your lordship. Who got this order from this court?
no, Mr. Bandhavare, that is not required because your argument is that it is an judge sheet is an opinion, it is tentative on the basis of that is your argument.
Very nice I am just
No, as you are
I am who is on which side is very difficult now to understand.
ready to track your Bible.
For not conducting the aptitude test, then selection cancel of the selection process only for untreated candidate is only bad in law. Untrained, trained, everything will go. These are practically possible now at this stage to after 2016 to 2025.
Because the trend also faced aptitude test.
Yes, same. Only extra, the trained is also having the certificate. We untrained also obtain the certificate. Therefore, your lordship is facing with the problem. If this acceptance is taken in, there are more than 60,000 teachers will go.
Hmm.
42,000, sorry, my lord. Not only us. Neither untrained was made party, neither trained was made party before the single judge.
Yes.
And unfortunately, my lord, this is a very unfortunate for us. Although the board is represented by here the Learned Advocate General.
He has left.
No. I will not blame him because he was not there at the initial stage. Neither Mr. Rahul. Ratul was there in the. See the proceeding. From the very beginning, board did not contest the case at all. Not a single thing has been said. The council who appeared at that point of time.
He put this question to Mr. Dotto, Mr. He has
Our anxiety is that, my lord, everyone was not required to be calm before the court. But when states and the state authorities are represented, my lord, my lord, society expects everybody's case will be argued properly.
Yes, Mr. Bandhavare.
Next point, my lord. Citing examples of few irregularities cannot be ground for setting aside of the 2000 selection process.
Citing?
Few candidates.
Oh, yes. That you have argued, Mr. Bandhavare.
No, this point I did not argue. They have
Yes.
taken, but it was lordship's
So
point. My lord, it was your lord's. My lord, Justice Chakraborty's point. Lordships have argued. I am grateful to your lordships.
No, we have not argued.
Not argued. Your lordship have, no, lordship.
No, Mr.
Not argued. Not. I am sorry.
Mr.
Missing.
Yeah, yes,
Sorry.
Mr. Anindo Mitro and
No. Here
that gave the
this observation had fallen from your lordship.
No observation.
Very good. I am with you.
No.
Very nice. Now, few incidents.
Yes.
Can it be a ground? Few incidents.
Yes, it.
Then when you are taking the 32,000 employment, you prove it 32,000 case.
Yes.
After all, it is a litigation.
Yes, Mr.
This I am coming. Documents regarding publication of panel. The writ petition, kindly see. Writ petition itself in 2009, Miller 19.
Monica Das or Robiul Sheikh.
Niladri Jana.
In the bunch of Rabiul Sheikh.
In the bunch of Robiul Sheikh.
Huh?
Here is.
Hard with Rabiul Sheikh.
It was hard with Robiul Sheikh.
Oh, it was hard with Robiul Sheikh?
Yes.
Yes. What you're
Brother,
saying?
Rabiul Sheikh and
আরে তুই এখান থেকে দেখা না তুই অন্য জায়গায়
paragraph 35, 25 and 26 annexure আছে।
ক্যানেক্সারটা দেখা 35, paragraph 35. আর কপি আছে?
হ্যাঁ,
দিয়ে দাও।
আপনার
Your
জন্য-
petitioner says,
আপনার জন্য আছে এখানে।
তুই কোথায় কি রাখছিস?
Paragraph 35
হ্যাঁ, paragraph 35 of this kindly take the kindly
of Robiul Sheikh. No,
Niladri. Tagged matter, Niladri.
one judgment was delivered, no? One
Niladri
judgment
Jana.
was-
But I am saying the petition.
But the judgment was only in respect of Robiul.
Common judgment.
Common judgment.
Please, oh, no, please
আছে,
check
আছে,
up.
আছে, আছে,
I
দেখি,
think it
স্যার,
is
দেখেন,
only Robiul.
দেখেন স্যার, রবিউল শেখ সাথে নীলাদ্রি জানা।
No, no. No, no. Robil Sheikh with the Niladri Jana. It is there. 2023 SCC online, page 710.
Where you are showing.
Pilot, kindly come to paragraph 35, no?
35
Paragraph 35. Your petitioner states that from the published panel of the district Dokhin Dinajpur, it has been seen the lowest score obtained by candidates are entered at is 16,000.436 over the lower course score so and so. The your petitioner states that those marks are higher than. Then, unless you have seen the panel, how can you do it? How can you make this pleading? Next paragraph is কোথায়?
25 26 এ আছে।
25 তো পড়া হয়ে গেল, 35 তো পড়লাম।
হুম।
তাহলে কোনটা?
প্যানেল গুলো 124 থেকে আছে।
Bharat, kindly come to page 124.
Back side।
Is not readable, but see, from 124 the panel has been annexed.
ইন্ডেক্সে লেখা আছে
Panel, and kindly see in the index.
লিস্ট অফ দ্য ফটোকপি অফ লিস্ট দেখো।
Bharat, kindly come at the top of the
No, the judgment, was it a same
batch matter,
judge?
batch matter.
Acha, acha, acha.
Bharat, this is a,
Page 124.
yes,
ইন্ডেক্স
This has been told to us, Mr. Bandyopadhyay, that the panels were annexed with those
Yes.
restrictions.
therefore the panel was not published, it was not the case. আরো বেশি বলিস না, জজ সাহেব বেশি চাইছি না। বোর্ড বলে দিয়েছে, এগুলো বলে দিয়েছে, বিকাশ করে দিয়েছে। But these are the points, Milord. Almost every other, my other friends all have dealt with. I don't need to repeat it. Milord, I will just beseech to your lordship, Milord, I will sum up and I will say to your lordship.
Yes.
Kindly just. My lord, these 32,000 persons had been employed, right, for 2016,
70.
17, and 2000 selection for 2017. This is continuing. First round litigation, second round litigation, all have gone. Milord, very recent, Milord, Justice Joymallo Bagchi's judgment, did I cite it? Justice Joymallo, precedent that Milord, one of the judgment I cited that is delivered by in the Supreme Court by Justice Joymallo Bagchi. Binding precedent has to be followed. Litigants should not be forum shopper. Renuka versus State of Karnataka, 2025 SCC online, SC 970. Now, when Justice Mousumi Bhattacharya was taking matters, 970, paragraph 17, I cited this judgment.
That was a coordinate versus coordinate, not a single bench versus coordinate.
No, what is the proposition of law has been
Proposition is if you are not agreeing with a single judge,
proposition, binding effective, see, proposition.
that is
That binding effect is there. The one of the word used expression has been used forum suffer, which is applicable in this case. There are a number of judges who have taken the matters of this, not removed. Justice Mousumi Bhattacharya, Justice Amrita Sinha, even my Lord Justice Tapobrata Chakraborty was sitting singly. Even my Lord Justice.
Didn't take up this matter.
No. Education matter you have taken, na? That time it was not moved. I am saying it was not moved. That is, I am not moved. I am saying that. Then Justice Orijit Banerjee, Justice Hiranmoy Bhattacharya. The moment this jurisdiction has come, all that petition. This is called forum shopping. This is what I am not on that. I am not, I am
Yes, your
using a legal expression, my
yes,
lord.
forum shopping. Yes.
Right? Forum shopping. I am not interested in any name. This name has no value now today. Now, my lord, next is now this is continuing, my lord. Would your lordships kindly consider? My lord, consideration before your lordship is this: whether the matter was decided in accordance with law by the court by applying all principles of law. By applying all principles of law.
Yes.
Or whether the single judge has adopted a procedure which is unknown to the settled law.
Yes.
If it is not decided on the basis of the law fixed, it is taking away of the livelihood of others. 32,000 not before your lordships. 32 into 5. 1,60,000, 70,000 livelihood are at stake.
Yes.
Lord, this is my I am
Thank
just so grateful, deeply obliged. You all lordships are so kind to me, accommodated me. I am deeply obliged to my Lord Justice.
We accommodated everybody.
No, even then you were lordship today. No, I express, at least allow me to express my gratitude.
No, not that. This is the usual practice.
My Lord, I express my gratitude to
You
you.
had been seniors. Mr. Bhattacharya is there, Mr. Bandyopadhyay. Both of you are senior.
You are, and apart from that, you are so kind.
No, এটা আবার kind.
Your magnanimity kind.